My name is Caoimhe Gleeson. You're all very welcome to this evening's seminar, not webinar. We're used to doing webinars. We're webinared out of it for the last 4 years, so it's wonderful to have people in a room. It's amazing. And if we start doing very funny things that are normally to do with webinars, forgive us, we're so used to moving things on quickly. So this evening's event is sorry, now I'm completely mixed up in my notes. So anyway, we'll start again. So I'm delighted to welcome you all to this event with His Honour Judge OConnor, who has generously given of his time this evening. So before we start, there's some short announcements that I want to make, and I'm after messing up this. Sorry, lads. So excuse me. Whoops. All the way back. There we go. Okay, so there's some short announcements that I want to start with. First of all, this webinar is being recorded and there are photographs been taken, so we will send you the link to the recording after the event, and you can also access the link to the webinar seminar on www.assisteddecisionmaking.ie. We will also send out an email with a certificate of attendance to all attendees for your own records. Details of how to apply for RCPI, CPD will be in that email, so you don't need to email us separately about that. For registrants of Corru and the NMBI, and then members of the Law Society and the Bar Council of Ireland and the Dental Council of Ireland can use this certificate as proof of attendance for your own CPD record. Can you all ensure that your mobile phones are either switched to silent or airplane mode now, so you don't get mortified when it goes off in the middle of the speech and one of us stands up and stares at you? So do that now if you can. And thank you for all that submitted questions. We got a lot of questions in advance, which we have weaved into the questions that Mary is going to work with Judge OConnor on. There may be time after, so what we're going to do is have, and Philip is going to talk this through, but we'll have a conversation with Judge OConnor and Mary, and then there'll be a panel discussion. Then after that, we may have time for questions. So if we're not able to address your questions, you can send them in to us separately then at adm@hse.ie. Just to say as well, we'd like to extend our thanks to the National Safeguarding Office and particularly to Tim Hanley, who I think I saw somewhere in the room, who provided support for this event. So this event is thankful and grateful to the support of that office. Finally, I'd like to extend my own sincere thanks to Judge OConnor for his ongoing support to the HSE in helping us navigate this new legislation, particularly in relation to matters to do with the Nursing Home Support Scheme. We're really, really grateful for your generosity of time in the last few months as well. So without further ado, I'd like to hand you over to Dr. Philip Crowley, who is the National Director for Strategy and Research, who's going to open this event. Thank you.
Thank you, Caoimhe. It's lovely to be here and see so many colleagues here. Welcome to the members of the judiciary. That's a tough word to start with, I have to say. Philip Crowley is my name, as Caoimhe has already introduced me. I'm delighted to open this evening's seminar, a really important event, I think, for us, and part of a kind of a really important collaboration. It's symbolic, I think, of the collaboration that we've been so grateful for. We're especially grateful, obviously, to His Honour Judge John OConnor for agreeing to come and share his judicial experiences of the operations of the Assisted Decision-Making Capacity Act 2015 in his court at the Dublin Circuit Court. So the purpose of this evening is to explore with Judge OConnor what has been happening in relation to decisions pertaining to decision-making representatives and to reflect on how to ensure that the spirit of the 2015 Act, which is about upholding the human rights of the relevant person, remain at the centre of all decisions. The event is organised by the wonderful HSE National Office for Human Rights and Equality Policy, most of whom I hope you all already know, a wonderful group of people, which provides strategic oversight to us in the HSE in relation to the Assisted Decision-Making Capacity Act 2015, amongst many other things that they do. The team are always trying to find ways of collaborating with key stakeholders. I think that's really the only way that our HSE generally should be working is in collaboration with others to try to achieve our goals. And this is a very prominent aspect of how the Office for Human Rights and Equality have been working. Because we believe, particularly in relation to the 2015 Act, it will only change lives if we collaborate with all stakeholders who have a role in supporting decision making. Tonight is one such collaboration, and we continue our long collaboration with the wonderful Professor Mary Donnelly, I don't know how many times I've introduced you at webinars and now at a seminar. We're old friends at this stage, although we don't meet that often. It's nice to meet this evening. Professor at the School of Law in University College Cork and a long-time advocate of human rights and equality. Professor Donnelly will chair this evening's event, and which will commence with the presentation from Judge O'Connor, followed by an interview, as Caoimhe has already said, with Judge O'Connor and Professor Donnelly, and this will be followed by an expert panel discussion, and that's where we'll try and deal with as many of the questions already fed in to us. We're delighted to be joined by you, a stellar group of people who will all play unique roles in supporting the implementation of this really important 2015 Act. And after the panel discussion, we hope we'll have time for some questions from the floor. And we hope this will be part of an ongoing collaboration with the judiciary, and I'm quite certain that it will be. And I'd now like to hand over to Professor Donnelly to chair this evening's proceedings. Mary.
Many thanks, Philip, for that very kind introduction. And I suppose to take this opportunity when I actually am with them in person to reiterate what Philip says about the extraordinary work done by the National Office for Human Rights and Equality. It's a very small team of people, but their foresight, their prescience in terms of recognising what had to be done in relation to assisted decision making, and their leadership is absolutely second to none. And it's a great privilege for me to be able to work with them. It's also a great privilege for me to be able to introduce Judge John OConnor. His Honour, Dr. John OConnor, has many law degrees, including an M.Lit. From Trinity College down the road on capacity law, before it was fashionable, I think we might say, Judge OConnor. He also has a PhD, he's a solicitor, and he's now a judge in the Circuit Court assigned to the Dublin Circuit. He's the principal judge in the Circuit Court on the implementation of the Assisted Decision-Making Capacity Act of 2015. Prior to his appointment to the Circuit Court in February of 2019, Judge OConnor was a judge of the District Court. And in that capacity, he was the principal judge in the Dublin Children Court in Smithfield for 6 years. He's a former chairman of the Mental Health Tribunals, and he's currently an honorary professor in law at Nottingham Trent University. And he's a frequent lecturer on capacity law. And we're very grateful to him for taking the time to be here today. So I hand you over now to his very capable hands. Thank you, Judge O'Connor.
Thank you very much, Mary and Philip, for that very generous introduction. I'm not sure my capacity recognises it, but thank you very much indeed. Just by way of some background, Mary said that I was in the District Court beforehand, and I qualified as a solicitor, as my children say, before dinosaurs, and I was for 30 years in practice, and I did a lot of work in this area. But as Mary said, we did, although at different times, share a supervisor, and when I went to him to say that, look, I'd like to do an M.Lit. in capacity law, he said, oh, that's a bit narrow. And I said, well, it's civil, and he said, no, it has to be criminal as well. And then he said, you better do mental health. So anyway, it was, and then when I finished it, he said to me, it's a bit broad, isn't it? Anyway, I was in the Children's Court then for 6 years, and I know some colleagues appeared before me in relation to it. And one of the things in the Children's Court was, as you know, we have the Children's Act of 2001. It took forever and a day to get through the Oireachtas. It was 1992, I think, and then 2001 it was enacted, 2007 by the time it was fully implemented. And prior to that, and the reason why I'm telling you that, there's some similarities with what we're dealing with now. We had the 1908 Children's Act, the Children's Charter, which was based on Victorian best practice, regarded as quite innovative of its time, but it was a long time ago. And then we had the United Nations Convention on the Rights of the Child. Ireland signed up to it, and it's one of the great conventions, and that was the Children's Act brought in. And one of the great things was, in fairness, when it did happen, there was good collaboration. Irish Youth Justice Service collaborated with the Gardaí, the probation services, and the various other bodies involved in it. And while the judiciary were not, for obvious reasons, involved in that. There was a lot of collaboration and cooperation with them. I do remember actually when I first became a judge in the Children's Court, the director of the then director of the diversion program said, "Are you another cranky judge, or you're going to here to learn?" And I laughed, and we got on very well. But with this act, as you know, the United Nations Convention of the Rights of Persons with Disabilities, and we enacted that. And obviously because of Article 29 of our Constitution, although we signed up to it, it's not law unless we actually introduce our own legislation. And that's, of course, the Assisted Decision-Making Capacity Act, and that took forever and a day to get through the Oireachtas, even with the amendments, but eventually we're here with it now. And I'm very grateful to be here and for the collaboration, and I have, as been said by both Philip and Mary, great collaboration with the HSE, with the DSS, and with the various professional bodies and others as well. So it's all new to us. I know you all expect me to be the expert in relation to this. I'm not. There's other experts here, and they'll answer the difficult questions, but we'll have a go at it anyway. So, now, the total number of cases that we have since it started in April, but really it only started going during the summer. We've had 451 cases. As expected, approximately 35 to 40% are taking place in Dublin, and there's quite a lot in Cork in regards to that. Those statistics are from the Court Services UCMS system, and they're the total cases, so it's one case per relevant person. Now, the 186 cases in Dublin, you'll see that there's a bit of a discrepancy when it comes to the number of cases that I have dealt with, and I'll explain that in a second now. So I've dealt with 148 cases, 74 DMROs granted. The discrepancy is basically because we've had vacation sittings and the UCMS system, it only captures cases as they're filed. So there are cases that have not yet made its way to court, and there's a 21-day notice period. What happened with the other cases? The 74 cases, some cases were adjourned to get updated proofs. The average number of court appearances is almost 2. So in some cases they've got through in the first go, but most cases there's 2, on occasions it's 3. And you'll see why that is happening. People are not aware fully of what's involved, and there's matters to be dealt with. There were cases withdrawn. The relevant person passed away in some cases. Ex parte consent applications granted, but capacity applications not lodged. And there were cases withdrawn on the party's own motion because, for example, maybe a co-decision making agreement was more appropriate. Now, in relation to this, the ex parte applications, you'll see that cases requiring consent were 30% and 70% not. So the 30% cases before the court, they are cases in which the HSE, they are about 1/3 of those, 9% of the overall cases. Other groups are siblings, parents of adult children, and nieces and nephews. And that's much the same throughout the country. These are actually my own statistics, but it's much the same, I think, otherwise. Of the nursing home support scheme, of the 148 cases, 109 cases seek orders relating to the nursing home support scheme. Now, they might require other orders, but that's, you can see that there's a huge emphasis on that. And I think one of the problems is, and I know that was discussed at the beginning, is the forms can be quite complicated. Could we make them simpler for the nursing home support scheme? The danger with that is that usually people want more than just the nursing home support scheme. So, you know, I'm talking to Jim Finn about this, but we may do something in the forms that maybe an appendix to it to deal with the nursing home support scheme, but we are aware of the issue in relation to it. Now, Section 139 of the Act, this is really crucial. It says the relevant person shall, it doesn't say may, shall attend court. unless the court dispenses with that. Now, just my own notes in relation to this. I'm a little disappointed, to be honest, with the numbers that the relevant person is attending court. And I'm going to explain to you the reasons why that's really necessary. It's only 7%. We're trying to be as user-friendly as possible so that we can actually do them in person or remotely. If we don't, and we do dispense with that, we're going to have to get the voice of the person somehow or other. Quite often that's an advocacy group. It doesn't have to be an advocacy group, but I do have to get the voice of the person. And I'm going to show you and hopefully demonstrate how that is totally different from legal advice. Okay, and it's totally different from the capacity assessment itself. I think what might be useful just at this stage, because I know it comes up as a question, why do we need the voice of the person? Why, in a lot of these cases, 90% of cases where people may lack capacity in relation to it. I'm going to tell you a story about myself. When I was in the children's court one day a few years ago, I went upstairs to look at the old ledgers. And these were the ledgers in which children were sent to industrial schools, 2, 3, 4 years, 5 years. It was quite chilling to see it, beautiful copper plate writing. And we know that there were court orders. The voice of the child was not seen in that, and judges signed those orders. And we know that what we signed them to was to hell. And it's something that just can't happen again. And I think what's reading just from the Court of Protection, what matters where they have it, and they have it at their booklet, I think it's worth just reading out. The reasons why it's important to involve the relevant person in proceedings that involves decisions about their life and future well-being include the following. It is their life, and the proceedings are for their benefit. It's about their dignity. Not allowing or facilitating participation degrades the individual and strips them of the rights as a citizen. One of the two basic principles of natural justice is audi alterum partem, no man is condemned unheard. A legal right of access to courts for citizens whose rights are affected by the litigation is a basic constitutional right. It's a basic constitutional and our constitutional right. Participation provides a procedural safeguard against arbitrariness. The person can ensure that questions are asked of witnesses and they are challenged on key points. And we've actually found where a relevant person has attended court, it has been very useful, to have asked questions. And continuing on, it says, the judge understands the emotional context and the importance of the decision to the person. I think that's really crucial. It improves the quality of the decision making, and it can often change the outcome. So we do have cases where the relevant person has been in court, or we have cases where we've investigated further, not just relying on the medical report, not just relying on legal report or the legal submissions in relation to it, where the decision is actually completely different. On some cases, in fairness, it is a minority of cases, there's obviously safeguarding issues. We had one case which was really a family law case, very awkward individual, but certainly had capacity. And we were able to deal with that because we actually met with the relevant person in relation to it. So I think that is crucial. I'd like to see that figure increased. How we attend to that, I'm certainly open to suggestions how we can make it better. I know in England that judges do go out sometimes. I'm not recommending that I go out to the hospitals or nursing homes in relation to it, although I did have one case today, I think, where there's a possibility that I might have to do that, where the relevant person is not anxious to engage with an advocate or engage with somebody else. But I think that is a crucial section in the Act, and I think it's something that we, and it's been emphasised, obviously, in my decision, in Joan Doe, but it was also emphasised in the High Court in the KK decision. And Ms. Justice Niamh Hyland was very emphatic that you have to somehow not being too prescriptive about it. We don't have to say you have to do this and this, but you do have to make some efforts in relation to it, and that is separate from legal advice. Legal representation for the applicant. Now, you can see there's a very high proportion of lay litigants, 40%, 60%. Some of that is really down to the fact that when you ask the lay litigants, they say themselves that they can't get legal representation. Solicitors don't want to deal with it. It's too costly. And some of the lay litigants are lovely to deal with. They go with you. They kind of collaborate, and they, and we've had some lovely stories, and they really do appreciate it's about their mum or their dad, their rights. They appreciate that they have to be respected, and they know that they have work to do in relation to it. And, one of the great things, I really am grateful to the HSE for this. We did have an issue with the Fair Deal scheme and the Nursing Home Support Scheme, Ancillary Relief, where the paperwork wasn't done right. And we thought, well, could we do this under Section 48 if they're almost there? It's not as if and one of the reasons for this is, the transitional care takes 10 weeks, and quite often they leave it until week 6, 7, or 8, 9, and then who's going to pay for all of this? And if they have the work almost done, they may be missing an affidavit or there's something else done, we've agreed to come up with a draft order that is used in relation to it. And just in that regard, we are trying to get consistency with the judiciary across the 9 circuits in relation to it. Fully accept that we're all a bit all over the place to start with, but I think you'll find that improved enormously. We did have a talk, we had various talks leading up to it, but we had a talk on the 2nd of February, which Judge Jeffrey Shannon was here, and myself, we came up with draft orders, and then we had 14 questions. We very carefully made sure that we didn't have subsidiary questions, said they can write in for those. But in any event, I think that will improve, hopefully, the right across the country, and that it is consistent. Legal representation of the relevant person, I think this is interesting. When we started this, people couldn't understand why you needed legal representation for the relevant person. Well, first of all, they're entitled to legal aid. It's not like a question that should be assessed. It's provided for in the Act. And what I want from the legal representation for the relevant person, as opposed to for the applicant, is not another capacity assessment. In fact, in a lot of cases, as I say, they won't have capacity. I do want to do what lawyers meant to do. Is there conflicts of interest? Is there a better way of dealing with this? Is there a co-decision making agreement? Is there, for example, can we do a trust, for example? And is, for example, you might have a situation where the Fair Deal scheme is being used and the applicant would like access to the relevant person's accounts because they want to pay all the household bills, and there's obviously a conflict in relation to that. Now, that has improved dramatically in recent times. You'll see that just a note there, the last 20 decision-making representatives granted, it's gone up to 55%. It should be really in most cases. You're entitled to legal aid. Now, I give credit to the people who appear before me from the Legal Aid Board. They're very good. But I'm afraid it isn't consistent around the country, and I'm afraid people don't know that they're entitled to legal aid. And I'm afraid that is a big issue. And we've had cases where people have come into court saying that they've rang for legal aid and said, well, actually, can you send in an application form? We need PPS numbers, we need various, and we'll assess whether you're entitled to it or not. That's not the case. You're entitled to it. They can ask for a contribution. I think the practice is they generally don't unless there's a lot of assets that are there. They tend not to do it for social, for care orders or for matters like that. I'm not trying to do my own profession out of work, but it's an awful lot less from a cost point of view than than getting a solicitor to act for the relevant person and a separate person acting for the applicant. So I'd like to see that figure definitely increase. Voice of the relevant person. Now, you can see the advocacy group is very good. National Advocacy and SAGE are right up there in relation to it. I know in other parts of the country there's other advocacy groups, but they're the ones that I tend to deal with in Dublin. Other means, so just to show that I don't have to have a particular advocacy groups, I do have to have somebody who's independent, so it can be an independent social workers report, it could be an independent solicitor acting for the relevant person. Do I need an advocacy report if I have the relevant person in court? It depends on the circumstances. I, again, can't be too prescriptive in relation to it, but I certainly need some voice of the relevant person if they're not in court. You know. DSS panel members and applicants. At the moment, the applicant proposals, as you can see, is 80%. A lot of those would be to do with the Fair Deals scheme and family members. I expect the 20% for the panel DMRs is going to increase. I've noticed it increase lately, but maybe others might have a different view in relation to it. I expect as more complicated, particularly financial matter cases come in, we'll have that. So that's the slide to start with. Probably time for questions, isn't it?
Many thanks, Judge OConnor. Can everybody hear us? Smashing. So, oh, you certainly can hear us now. As you know, we've had questions submitted and people have been really, really interested and have submitted a whole array of questions. You've addressed some of them in your talk, so I'm going to sort of work through the questions. And sometimes they might be phrased a little bit differently to the way in which you sent them in, but thank you very much to all of you and to anybody out there who submitted questions. I'm going to start with a very general question, Judge, and that is, what do you think is working well? I mean, and obviously this is within your experience, and what do you think is not working well with the ADM Act to date? Where would there be improvements?
You might say I would say that because I'm here. I think the HSE have got it. I think they understand what's involved in going forward. They tend to be quite collaborative in relation to what's needed. What's not working well, I think lawyers need to improve, to be blunt about it. Some doctors' reports are excellent. Some doctors' reports are still giving sort of a Donald Trump 5-minute, I can be president, I aced it, I should be president of the United States report. Yeah. Professor Sean O'Keefe has done the template in relation to it. I don't think I should have to keep giving that out in court, but I frequently do give that out. I think there's a problem with the Legal Aid Board generally. I think that is, they have a panel, they haven't used it, or I'm not aware that they've used it yet. I think we're talking about people's very vulnerable people, their fundamental rights. The Oireachtas, as I understand it, have provided funding to deal with this. I would like that to be far more active in relation to it. Yeah.
Great, that's really helpful. And we might start, following on that theme, from this idea of voice. And you've really emphasized that in your presentation, and the different ways in which voice can be kind of communicated, and why it's so important. And I wonder if I could ask you, and the other thing you've emphasized, which is so important, which is the distinction between legal representation and voice, that the two are not always the same. Yeah. In terms of dealing, when you do have the relevant person in court, how does that go? I mean, how do you find that experience works for the relevant person? Because sometimes people might be, nervous about bringing the relevant person to court because they might think it would be traumatic.
Yeah.
So,
well, I think that's a really good question. We've had a few people in court itself. Quite often they've had a support person with them. A social worker in particular, And it's been very good because you get the feedback. You do need to give it, well, you need to give all the cases time. But if you have, it could be a speech and language therapist, it could be a social worker. My experience is generally social workers. And they're quite helpful in the sense, not quite, they're very helpful. They,
I'm looking at some social workers there.
but they, you know, they give you context by saying, you know, and they may even say beforehand, look, this person's quite nervous about, well, I think anyone going to court is quite nervous, but, and they will say there's speech impediment or whatever the case may be. And we found actually, I remember in one case where it was adjourned for very good reasons, and it was back the second time. There was far more interaction on the second occasion. I think the relevant person was...
Which is more familiar.
And in that particular case, it was interesting because it was an acquired brain injury. So it wasn't one of your sort of fair deal type cases. And he was well able to give his will and preferences. But there was issues in relation to capacity for certain things and not for other things. It was a classic functional assessment type issue,
Yeah, that's really helpful, and actually leads me on, I suppose, to the significance of the functional assessment, not just the way in which the forms are filled out, but the actual importance of that functional assessment and the specificity of it. Would you like to talk a little bit more about that? And
yeah, I mean, there's,
you know,
it's the same as in lawyers, the same in doctors. I'm sure Sean will verify this. Some people are excellent at doing it, and some people just have a resistance. And you know, I've had occasions to say, look, that'll do them, which it won't. We try to be constructive in relation to it. So sometimes I might have a social worker's report with a doctor's report, and I might be able to put it together with that. And I have an advocate, and I have a lawyer, and all the rest. And it depends on the context of matters. But we do have, and I'm quite taken back, the amount of medical reports coming in, which are done really on a diagnostic, test, and perhaps failing to understand what a functional assessment is, and that is the whole thrust of this act, you know. But I do try and if I can fix it, I try and fix it. And if sometimes you which is quite good, and it doesn't have to be a doctor. It can be a nurse, it can be a social worker, it can be a speech and language therapist, as you know, it can be a midwife. But you do have to know the person. You do have to be independent. The fact that somebody's a patient of yours doesn't disqualify somebody. What might disqualify somebody is that if you're going to do say a major teaching hospital wants to move 200 patients to a nursing home or nursing homes, and the medical report is a social worker who's in charge of moving the people. So, I mean, it's kind of common sense, really. It has to be independent. But I'm not discounting that report. It can be quite helpful to fill some gaps in relation to it. But, yeah, I mean, again, it's back to the issues of the voice of the person. If I could see the person or I could talk to them, it would make a huge difference. I fully accept that a lot of people can't come into court or can't be online. But if they can't, then we need to be proactive in how we deal with it.
Thank you. That's really helpful. And I suppose one question which we got in, which is, as you've absolutely correctly said, a report, a capacity assessment can be done by a medical professional or by one of the allied health professionals. And some people wonder, do judges prefer doctors, or is there a sort of an innate prejudice in favour of doctors? I'm not talking about the quality of the report, but in terms of doctors' reports, because I suppose they've had a longer tradition of that. And have you any thoughts on that?
Well, I've done the courses on unconscious bias, and we shouldn't if we do. Provided the report is comprehensive enough, it should be fine, you know.
Yeah, that's very helpful, and I imagine very useful for people to be aware of. But that I suspect is one of your take-home messages out of today, is that the quality of the report really has
quality
to be
of the report. I mean, the fact that if you met somebody for 20 minutes and that's all you can do in relation to it, it needs to be supplemented. It's very hard when you're talking about depriving somebody of their rights. It could be very major financial rights, it could be major personal rights, and you're going to do it in 20 minutes.
Yeah, thank you.
It's fine to be President of the United States, though.
Yeah. An impression I'm getting from just listening to you is you take quite a problem-solving approach in the sense that you try to solve it if you can, but then sometimes obviously you have to adjourn, sometimes you can't solve it. What kind of circumstances lead you to adjournments typically, or lead to the matter being adjourned?
Usually because the paperwork isn't right in relation to it. Now, we do operate, I'm not sure it's my function, and I know some of my colleagues say, listen, really, is this our function to be doing this? But we do have the brochures, from Advocacy Services or the Legal Aid Board, or indeed Sean O'Keefe's precedent, even though it's on the HSE website, just to let people know in regards to it. But we do try and collaborate with people.
Yeah.
Having said that, it's not just an inquisitorial type system. I mean, it does have to be properly investigated. We're talking about human rights, and so I do try and collaborate with people, but I can't take shortcuts, basically.
Yeah. Yes. And you talk again there about advocacy, and this is just kind of concluding our discussion of voice in a way. What do you expect from advocates?
Well, I think they do get it, in fairness, but advocates are exactly what they are. They're there to promote the voice or the will and preferences of the person. They're not there to give legal advice. They're not there to suggest legal. And I think that is a problem in any event. I mean, I found this when I was in the Children's Court. We were all talking about working together, collaboration and all the rest. That is very good in theory. The danger with that is we can start going into each other's areas.
Yeah.
And one of the problems was, I remember in the Children's Court, you could have, we say the diversion program with the Gardaí, getting into probation service getting into medical issues or whatever. That's a danger. There is a crossover, but we do need to know our boundaries. So, and I think the same for lawyers. They are lawyers. They're not necessarily, they can say I can't get instructions, but they're not necessarily the best qualified to do a capacity report.
Yeah.
Unless they have a particular training. There are some people who have that training.
And this theme leads on to talking a little bit about reports and forms. And as you know, of course, under Section 50, you can ask for further reports. Do you use that often? And what do you typically look?
Well, I'm certainly very conscious of Section 50, and I have suggested that on occasions. Speech and language therapist report would be an obvious example of one. Psychiatrist report, maybe. We tend not to make it as a formal order to date, because it hasn't been. We've had a few contentious cases, but generally speaking, we suggest it, and it comes in that way. Yeah.
And thank you. And continuing this theme of kind of reports and forms, Form 55C, I should say, which is the reply to the capacity application, for those of you who aren't as familiar with the forms as Judge O'Connor. Do you check that this has been completed by the person, or how does that tend to play out?
This was a tricky one, so I was glad to get this in advance, so I decided to write down what... Form 55C, that's the relevant person's reply to the capacity application. In practice, it's rare that we get that form. I do think it's a good idea. However, independence is the key in relation to it. In many cases where the form is lodged, it's quite clear the applicant has filled out the form and the relevant person has just signed it. So I think it would be a good idea if the Legal Aid Board or the advocate assists the person in filling out that form. The purpose of the form is to convey the relevant person's will and preference and opinions in relation to the application to the court. And we're back to it again. Presently, we're getting it from the independent advocate or independent social workers report, or, as I say, by the person remotely. But I'd like to see that more independently done, and I'd like to see it actually a bit more...
Having a bit more bite. Yeah. That's really helpful. And then that issue of service and notice parties and what the HSE can do to, or what do you look for in terms of confirmation that all notice parties have been served?
Well, it's in the Act
Yeah.
as to what we, so
Yeah.
we just see if that's complied with. On occasions, and the HSE have made it clear that for the interim orders where we do it for Section 48, that's to do with, say, the Fair Deal Scheme, that they are put on notice if we're going to revoke that order, and that's for obvious reasons that they have now consented to it. There is a danger if orders are made, and I think there was a situation where an order was granted and there's already a contract in place with the HSE, and they weren't put on notice in relation to it. Now, one of the dangers in this Act is that there's no appeals except on a point of law. And the danger with that, if it's not done correctly, you're going to have judicial reviews. And our experience, I think, and those of us who are involved with the mental health tribunals, was that judicial review was quite rife, as well as Article 40. So.
Yeah. And that was particularly the early days.
That was the early days. It's died down now.
Yeah. And that question of interim orders, were most, or has most of your experience of interim orders been in the context of the nursing home support scheme?
Nearly all. I mean, it could be in relation to medical decisions as well. I think it's important to bear in mind what we can do in the circuit and not. Sometimes I think it's thought that we can't do medical decisions.
Yeah.
We can.
Yeah.
The High Court, obviously, it's reserved to them end-of-life cases. It's also put into the Act that they can do other medical decisions. I think that's really for clarification that they're not prohibited, that you don't have to keep going to the circuit court as well as the High Court in relation to matters. But we can do quite extensive medical care decisions. They need to be relatively specific, though. I mean, I think the idea of just doing everything and anything wouldn't be great. Yeah?
Which is a really good way to move on to the next question. And that's to do with levels of specificity in terms of the applications. And could you talk us through that in the sense of, do you get some which are just anything and everything? And then how specific do you think applications should be?
Well, I know, and I'm looking at Anya here, from the DSS point of view, they do require it to be quite specific. For example, if you want to sell a house, I mean, the specific section in relation to the Act, in relation to that, we do need to know what are you going to do. Are you going to, I mean, it's not just a question, the authority to sell the house, we need to know that it's going into a specified bank account, and how the proceeds are going to be used. We're not mad about doing general care orders. And, there can be very specific orders. There can be litigation capacity because somebody's involved in litigation for various reasons. We need to make an order in regards to that. The orders are quite extensive. And I suppose to try and get some consistency, that was one of the things that Jeffrey and I were working on, is that we not only drafted the precedent template order, but the type of specific orders that are made in relation to financial matters, in relation to personal care matters, in relation to all matters, really, So there's quite an extensive area, but we do need to be quite specific, And we're not going to give it just a general order saying you can do everything and anything.
That's really helpful, and I think a really good message to get out there. Yeah. And do you see an improvement since you did that, or are you seeing that people...
I think generally there's an improvement since the Act started, I mean, myself included. I think, we're all a bit nervous when it started, and I think as we're going along, I know one of the things that was commonly made mistake by judges was when we made orders for, if two people were appointed DMRs, we weren't saying whether jointly or jointly and severally. That's a legal concept. And then it was coming back from the DSS, well, which is it? There isn't a default situation. But there's various things like that. I think we've cleaned up our Act a little bit in that regard.
And do you often find yourself appointing, joint and several, or whatever, I presume joint and several is do you, first part of the question, do you often find yourself appointing more than one DMR? Is that a relative?
For family members, yeah. Yes, and yes, most of them are joint and several, but not all.
Yeah.
Some people do want it as jointly. Where it comes to the panel, we tend to do one only, or else one for financial matters and one for personal care matters. If it's very complex financial matters, we might need somebody who's experienced in that area. And then for the quite complex personal care matters. That case of Joan Doe was two separate, yeah.
Yeah, and we might talk about John Doe because, first of all, thank you for giving such a thorough and really helpful judgment. And obviously that's one of the really important things is that, I mean, even you being here tonight is another example of that transparency and the courts being transparent. It's a really interesting judgment and it's a really interesting case. And I suppose maybe even, if you didn't mind, because maybe not everybody has read it, to talk us through the case a little bit and your reasoning and the choices made.
Yeah, it is an interesting case because, you know, the whole thrust of this new act is to do with will and preferences as opposed to best interest. Best interest is really what you use for children. It's what, you know, to an extent what the wards of court system was. It's not that we ignore it, but the thrust of this act is you know, will and preferences. And as you've said yourself in relation to it, maybe the difference is quite subtle in some cases. But this is an interesting case in the sense that this was a family unit where one member of the family, it was a sibling who didn't have children or spouse or partner, and had quite substantial assets in relation to matters. And the family stated, well, look, we know the will and preferences of the person, and they had quite extensive submissions in relation to it, including family albums and all of the rest. What was interesting in relation to that was the actual evidence that I got in court. You know, the psychiatrist stating, well, yes, at a certain moment in time, you know, a number of years ago, that was the will and preferences. Our condition has changed dramatically since then, and you know, so the will and preferences issue was far more nuanced. And then we also had the issues of safeguarding, we had the issues of conflict of interest, and also capacity actually to deal with complex financial matters. And we also had issues in relation to care. The person needed 24/7 care. Family felt that they could provide it. I held that they weren't really in a position to provide that. And also in relation to, there was a conflict I felt in relation to some financial issues. And but I was very emphatic in the judgment to make sure that it didn't interfere with the right of the family to visit the person. I mean, and you can't, and a DMR can't do that, can't prevent somebody unless there's an order from the court. You might do it if there was issues of, you know, of violence and all of that. One of the things I think in that family is that they really overreached in the sense, there was a lot of other complicated issues in relation to it. But one of the things was that they conflated the issue of advocacy with actually decision-making. Mm-hmm. And if they confined it to advocacy, it would have been great. But they actually wanted to override the very cogent medical advice, you know, really detailed medical advice. And they felt that, and they hadn't the qualifications to deal with that, they could override it. Yeah. So I think it was really to emphasize in all of that, I was trying to emphasize too, the voice of the person, how important that was. We had, in that case, it was actually a solicitor who was extremely experienced in the area of capacity, and they were able to, they had 6 visits, and they were able to communicate as best they could that issue, you know.
That's really interesting in terms of that number of visits needed, in a sense. No, that's obviously a complex case.
It's a complex case.
But that it did need that level of time. And again, I suppose one of the things about John Doe, that case, was it was the HSE was opposing the appointment of a family DMR. So it's kind of an interesting one from that point of view. Is that typically the circumstances in which you'll see opposition, or do you, like, is it, if there is going to be opposition, will it typically be from the HSE, or do you see it from other family members? And do you see opposition often? You know, how typical is a John Doe type?
Well, the HSE might pick up on it, but I might pick up on it myself in court, and most cases it's that way.
Okay.
And that's why I do need the independent advocate to be in court. It may come in with just an application from a family member who wants access to the house, wants access to the monies, And basically, you won't tell me how to look after my mother. I'll deal with it. And it's not, even to use the best interest, it's certainly not in the mother or father's best interest to deal with matters. And you can pick up on that, and then you say, well, look, you're going to have to put certain people, it could be the HSE, it could be whatever, on notice, and I do need independent verification. And some of those are actually withdrawn.
So, and there are cases where you always adjourn. You always adjourn and
Yeah.
look for more, and then, as you say, interestingly, they're withdrawn.
Yeah.
That's very interesting, and that's just saying a feel you get is probably too, but something is coming through from the evidence that makes you uncomfortable that this is not.
Oh, absolutely. And in one of the cases, which was a very high net worth individual, I mean, I could see that he was quite difficult, but it was a family law case. It wasn't. It wasn't an issue
And moving on from that to, again, the Joan Doe theme and the use of panel DMRs. I was very interested to hear you say that you thought, was it about 20% you were saying, and that you thought you would be seeing more. Could you talk us a little bit through that, whether those panel DMRs are because there isn't anybody to act within the family, or because you're not comfortable, or obviously a bit of each?
A bit of each.
Yeah.
I mean, in some cases, it's because there's no family member available, or they just don't want to deal with it in regards to it. In some cases, I have said that I'm happy with a family member involved in personal care or in health decisions, but I'm not comfortable with the financial matters. I mean, for example, there was one case, I think, it was not quite $1 million, but close to it. It was a High Court wardship case that came in, and the parent involved was going to take charge of this amount of money. I just really didn't feel that he had the financial ability to deal with that. So that was a panel appointment. Now, when you discuss with it, it's when you discuss it with the family and you discuss with their advisors or whatever, they tend to go with you by and large. If they're not going with you, that's kind of a red flag as well,
Yeah. Thank you. We're coming towards the end of this torture session for you, Judge O'Connor. Could I ask you just really a sort of a scanning the horizon question, which is, obviously, it's still not a year. I mean, this is still new. And how do you think we've done in a more general sense, and where do you see the law in this area going in the next 5 years or 10 years or whatever?
Well, it's going to grow just enormously. The whole issue in relation to it. I deal with, on Fridays, 16 cases on a Friday in relation to it. The ex-parties are now moved to Wednesday. I'll see very shortly that's going to be 2 days a week. I think, we've an ageing population. We're only getting to terms with it. I haven't had the discharge of wardships come down yet because that's obviously going to take its time to come into me. But that's going to grow enormously. So when the Act was introduced, when the amended Act was introduced, the Minister was actually it's Minister for everything. I can't.
Say that's what I call him.
He, because it wasn't Minister for Justice, it was 3 judicial appointments for it. But we actually had such a backlog in relation to just general matters, and it was before the Judicial Planning Working Group appointments were done. They were just gobbled up for crime, but we hadn't started off in the decision making. We don't have people specifically only doing this area. We have quite a small court. We have 46 judges in the circuit court. Reality, that's really down to about 40, because some of them, if you take into account people on the special criminal court, we have vacancies, that type of thing. So judges do have to be prepared to do
other things
as well in relation to it. But I do see this growing enormously. I mean, there are practical problems I know around the country. There was a view at the beginning that perhaps we should have specialised areas. Then there's the problem with the circuits is that, for example, the Midland Circuit goes from Mullingar to Sligo.
Yeah.
So do you have it in Mullingar, do you have it in Sligo, do you have it in between? So that has its own issues. But we are getting people who are, specialisation, it's like everything, specialisation does make a big difference.
Yeah, I think that seems very clear in terms of developing the necessary skills, because I presume you would agree that it does take a certain kind of set of skills for a judge to do this. This is a little bit different.
It does, yeah. You need to know the law, but you need to be, I think judges found it very different, because, we're used to people arguing on both sides and then making decisions rightly or wrongly. And this is a case where you're being proactive. And it's not inquisitorial in the sense of you're direct, but at the same time, you're trying to give information, you're trying to get the thing across the line. And you also need a certain, should judges have empathy? There's a doctorate. But you do certainly need a certain empathy, and you need a certain ability to be able to communicate with people. And, it's very emotional. I mean, you have a lot of people coming in, elderly people coming in. Going to court is traumatic for anyone, but for them coming in to make an application, they tend to be quite nervous about what to do, and sometimes a bit overwhelmed by what is involved. So, yeah, it does take a bit of skill.
Thank you very much, Judge. That was, I think, a fantastic conversation. I really enjoyed it. So I'd now like to invite our panel speakers to come and join us, please, on the stage. And as they're joining us, I'll be introducing them so we don't lose any of our valuable time. And I'll introduce them in the order in which they're coming up. We've got Anya Flynn, who's a graduate of Trinity College Dublin. She's a solicitor, former senior partner in the Dublin firm of KOD Lyons, where she practiced public interest law, including mental health and capacity law. She was on the panel of legal representatives of the Mental Health Tribunal, no more than Judge O'Connor, and the Mental Health Criminal Law Review Board from their inception. She's the current Vice Chair of the Human Rights and Equality Committee in the Law Society, former member of the Law Society's Mental Health and Capacity Task Force. 2023, she was named Irish Healthcare Person of the Year. Many congratulations, Anya, for that one. And in October 2017, of course, she commenced in post as the first Director of the Decision Support Service. Beside Anya, there is someone who I think we're all fairly familiar with, Professor Sean O'Keefe, trained in internal and geriatric medicine in Galway. He's a consultant geriatrician in Galway University Hospital. He's co-chair of the HSE National Consent Steering Group and a member of the Department of Health Protection of Liberty Safeguards Expert Advisory Group. And it doesn't say here, but he is clinical lead for assisted decision-making as well. And beside Sean, we have not Patricia Rickard-Clark, just in case you thought she had changed. We're very delighted Patricia's been held up in the Oireachtas, which is as good an excuse as you can get, really. But we are delighted to be joined by Bibiana Savin, who's the Assistant Executive Director and Case Management and Support with SAGE Advocacy. And this is an organisation which, again, it requires no introduction. It's an organisation which Judge O'Connor has spoken about. It provides support, advocacy and support to older people, vulnerable adults and healthcare patients. Thank you very much, Jacqueline. And then, apologies. And then finally, we're delighted to be joined by Susie Byrne. Susie is a disabled woman who's been involved in community work and campaigning on disability and equality issues for over 30 years. She works as a regional manager for the National Advocacy Service for people with disabilities, which provides professional, independent, representative advocacy for disabled individuals who may need support in decision-making. Susie is also a director of Iarnworth Éireann as one of the first disabled people to be specifically recruited to a state public transport board. And she's also Chairperson of the Board of the Irish Council for Civil Liberties. So thank you very much, Susie, and really delighted to have all of you here. I may as well start. I'm going to kind of work my way across, maybe going with one question each, and then we'll keep going as things develop, and hopefully I'll keep an eye on Caoimhe and she'll tell me when I'm running out of time. So we've had Judge O'Connor has talked to us about his side of the picture, as it were. What happens when the DMRO makes its way from Judge O'Connor's court to the Decision Support Service? What happens there?
Thanks. Am I audible? I am audible? Am I audible?
To me you are, but yeah, great.
As I think will be clear, and many of you will realise, the DSS isn't involved directly in the court process, as the application is one that's made to court. We may become involved in the course of the proceedings if a request is made for nomination of panel member DMRs for appointment. The order at the end is communicated to the DSS, so it comes to us under the Act for registration. We have the responsibility to maintain a searchable register. So essentially we take in the order and we deduce from it or reduce from it where it is naming parties and conferring authority on a DMR, and then that becomes the searchable register entry, and that's searchable by anybody with a legitimate interest or a member of a body or class of persons. So that's our responsibility. And then also laterally then it moves to supervision, which is probably one of your other questions. We then have a duty to supervise the performance of that order.
Okay, and as yet that's, I suppose, in its relative infancy in terms of development, or
depending on the authority that has been conferred in a DMR, if they have property and affairs responsibilities, then it comes to us. A report must come to us at the 3-month mark. Okay. That's contained in the Act. Not all of that was perfectly understood by DMRs in the early days of appointment. They do have to submit to us a statement of assets, liabilities, income and expenditure at 3 months. We have template reports. We will engage with the DMR. Supporting the supporter is one of our messages.
That's really interesting and something I actually hadn't realised, so thank you very much. Sean, if you don't mind, I'm going to turn to you to something which I know is close to both your heart and my heart, and that is the question of whether it's necessary to go to Judge O'Connor's or another court to seek a DMRO in situations involving treatment, so medical treatment. When do you need to go to court?
Well, as you know, Mary, we have our new national consent policy updated, and the policy position there is that we don't, in the vast majority of circumstances, that even though providing healthcare treatment isn't an intervention under the Act, then professionals should behave as if it were and look at the guiding principles. So we can work through the guiding principles of what is the will and preference of the person. In general, you're proposing treatment because it is for their benefit. And after consulting those, particularly anybody the person wants consulted, if all of those align, well, then you're able to go ahead with treatment without considering going to court, really as a kind of a rubber stamp where it's clear what should be done and is going to be done. And trying to go with DMR that way would delay treatment in some cases. It may not be an emergency, but it would interfere with providing treatment. So it's very much about trying to go to court only when there's a problem to be solved and where there's some conflict or some difficulty. And I often describe these as problem-solving tools. Yeah. And so that going to court and going to the circuit court for a DMRO may be what's required, but even in other circumstances, it may be a co-decision maker. I think one of the things we need to do is be much more alert to the use of co-decision making agreements where that would suffice for the person. And then even more so, as people, particularly in developing conditions where there's going to be deterioration, to say, would you engage in advanced planning? Yeah. You've got a better set of tools now. We have enduring power of attorney always. We'll have advanced healthcare directives if you wish. And saying that if you do that, then you're going to be the decision maker later through the person or the way you've chosen. Thanks, Mary.
That's really helpful, Sean. And actually, it reminds me, Judge O'Connor, of a question I forgot to ask you. So I'm going to pick up on it now, because Sean has identified the role of co-decision making. And obviously, by the time it comes to you, the co-decision making option should have been tried. What are you seeing in relation to co-decision making?
Well, certainly we have suggested on a number of occasions where we felt that you should go down that route, and that's been availed of. There is a specific provision. We've on a number of occasions we've thought about it, but it hasn't actually happened yet, and it's probably worth drawing your attention to this. One of the things we have to decide is, can it be done by co-decision-making agreement? And then what happens is we adjourn it to see if somebody can be appointed as a co-decision-making. And if they can't be appointed, or there's no one there to appoint, then we go to the panel. The panel can't be a co-decision-making agreement, but there is section 41(3) of the Act, which is really an important section, which states that when the DMR from the panel is appointed, they must take into account the will and preferences of the relevant person. And I think our guidance, Jeffrey and our guidance to our judges, is that we should put it specifically into the order, so that it's that they're aware of it.
Okay, that's really really helpful. Thank you, Bibiana. If I might turn to you and what you're seeing, we'd say through SAGE, but also from a safeguarding perspective, in terms of DMROs. What are you seeing out there? What issues are you seeing arising?
Okay, so is my microphone working? Yeah. SAGE Advocacy has been involved in progressing to date 191 referrals that are linked somewhat with Part 5 applications. Some are coming after a first hearing. Some other cases are coming well in advance when they're coming for different reasons, and after a while they'll end up going towards the court for a DMR application. So in 191 cases, I say the primary issue that we see is still a lack of awareness of the guiding principles. We also see that the requests for support for DMR orders are coming for very wide spectrum orders. They come to us saying we need to apply for an order, but we don't understand the process. Tell us why. What does Section 139 means? What Section 50 means? What is a functional capacity assessment, and why the letter that they would have, it's not okay. So we go through a lot of conversations with the family, with solicitors, with professionals. We find out when we go and meet the relevant person, as I said earlier, majority of applications are linked somehow with fair deal applications, but we find that the relevant person hasn't been told that they're there to stay. There are all sorts of safeguarding matters that come to light, and in which case we need to intervene. And so that's
okay. So again, that theme of the nursing home support scheme having been a very prominent feature, I suppose, of the early days, but then also the fact that the person themselves are very often not really aware of what's going on.
And I guess the most important thing, and I'd like to stress if possible, that when a request is coming to us for support for a report in Part 5 applications, that enough information needs to be given to the advocate in good time so that we can explore issue-specific and be able to capture as good as possible the will and preference of the person.
And you're not always seeing that?
Absolutely not. It's a lot of difficulty. We had a lot of trouble in the beginning to convince people that we are entitled to get that level of information in order to do a good job when we meet the relevant person.
Could I just say something?
Certainly.
Yeah. Where I think Bibiana is just reminding me of this, where advocacy groups have been very helpful. Also is that, for example, you may have bank accounts which don't require, they're relatively small, but they may require contact with the bank, and they have a vulnerable accounts section. They will deal with that. They will give access for maybe standing orders that have to be dealt with. So I think that's actually quite helpful, And the other thing is, in case I do forget to say this, because we're talking about co-decision-making and assisted decision-making agreements, the Legal Aid Board are also meant to help the relevant persons in relation to those.
Okay. And are you, or is anybody aware of the extent to which that's happening?
With Legal Aid, we collaborate with both the Legal Aid Board and Vulnerable Customer Unit. And in fact, that's one of the things we try to highlight, that there are less intrusive interventions that can and should be explored before it gets to the stage of a DMR application.
Fantastic. Thank you very much, Bibiana. So, Susie, and I'm going to give you a kind of a general question to give you a chance to really have a go at this. So the question I'm going to ask is what matters to you as a self-advocate in relation to the new legal regime, but I also want to give you a chance to identify where you see the problems with the new legal regime.
I think the fears of many disabled people around this legislation was that the guiding principles and the reason why we have the legislation in the first place would be forgotten about as people ran off to try and get arrangements put in place for people rather than support people in decision making. And I still don't think that we're at the supporting people in decision making phase, particularly about the least worst options, the presumption of capacity, remembering what Article 12 of the UN CRPD is really about, which is about presuming capacity and supporting capacity. So we need a lot more examples of decision-making agreements and co-decision-making, and how people's capacity is being presumed and supported every day without people running off and making applications for DMOs. No offence, Judge O'Connor, but we'd like to keep you and your colleagues busy indeed, and it's important, but there are lots of things that can be done beforehand to support people all the time. And in terms of the experience we have in the National Advocacy Service, where will and preference is our bread and butter, we're involved, not before the legislation was ever thought about, we were involved in supporting people in their right to make a decision and to be respected, and their rights for communicating, you know, and to be heard. And I think what we're seeing now, unfortunately, is the fact that applications are being made and relevant persons aren't aware. Relevant persons, and I'm glad to see the statistics around people having legal representation is increasing, because we are being told by people who are making applications, no, they don't need their own legal representative. By family members and clinicians who are making applications are saying, oh, if they have an advocate, they don't need a lawyer. And we are basically saying, when actually relevant people need legal representation if their rights are going to be taken away from them, or if somebody's going to be put in a place to make a decision on their behalf. And I suppose the other thing is about advocacy and the provision of advocacy supports to people. The terminology of report is being used. That's not in legislation. The Code of Practice for Independent Advocacy isn't talking about reports. And in NAS, our practice, and I'm around a long time, and we have 17 years experience of providing support to people in legal contexts. We don't have a defined role, but we had a lot of support to empower people to be heard by the court, whether it was in wardship applications, discharge of wardship, in the childcare courts where we support parents with a disability. We're not writing reports, but what we are is trying to develop and hear people's will and preference and support that will and preference to be heard in court. And it can't be done on the basis of 2 30-minute visits. And very often, we know that we will receive referrals from people who are making applications, and judges will recommend that advocates are appointed to support people. But we're also involved in long cases with people where we've known people for a very long time, and we can help people be heard, either that's in court or writing letters to the court or remote or through social stories, and with the assistance of speech and language therapists and others. And advocates need the support of those clinicians as well when we're getting to know people in order to support their voice to be heard. So there's a lot of work to be done there as we develop practice. And we're all new at it, is the other thing to say as well, even though we have experience in other fora. But I would really emphasise the guiding principles and the least worst options. We've got to do a lot more work on those. And to stop seeing the DMO application as the hammer to crack the nut, which is about moving people out of a hospital bed into somewhere else, which is a lot of reasons why we see these referrals being sent into us. And we're going back to, hang on, have you asked the person where they want to go? Why are we doing this first, and what are the other options? So.
That's brilliant. Thank you so much, Susie, because I think it's... I think it's really important, because obviously, because we're talking here with Judge O'Connor about what happens in court, it's really important to bring us back that ideally we'd like to do you out of it, not quite do you out of a job, but we would certainly like to see, and I think thank you very much for and indeed Sean, for just reminding us that this is not the obvious, sometimes it's needed, absolutely, but it's not the first point of call. Anya, I might turn to you with another question. I'm okay, am I, Caoimhe? I'm watching Caoimhe, who's going to tell me when I should stop and open it to the floor. Yeah. So I suppose, could you summarise? It's a tough one, Anya. About
1 minute, the experience of the DSS to date.
In respect
of
court orders?
DMRs. We'll go with DMRs, and then I might ask you a little bit around co-decision making and
Sure,
how that's going. But
sure.
we'll go with DMRs first.
And I would actually echo everything that has been said about the least restrictive approach. I think that needs to be commended to people. In respect of DMROs, all right, at the start, there was a bit of the DSS looking at orders and wondering what they meant, I have to say. And I think there was also a tendency for them to be quite general at the beginning, present company very much accept. But there was a tendency for them to be quite general and almost as if it was just the wardship in a different forum because it was commissioning a DMR to decide pretty well everything, which wasn't at all what we'd expected. Definitely that has changed for the better, so they are increasingly detailed. Some of them run to pages, but supplying the DMR with authority to do quite specific things, which I think should be the intention, matched to the finding of the person's capacity. Sometimes, and this might seem to turn that around, sometimes they are very specific but actually don't go far enough. We've encountered that a bit, where it takes the DMR thus far but no further, and a good DMR is recognising, well, actually I've been authorised to do this much, but in order meaningfully to be able to support the relevant person, I need to find the authority to do these next 3 things as well. So we are seeing some returns to court to get orders varied and expanded to good effect, and necessarily very encouraged by the idea of a template order. I think uniformity would be very helpful. It would certainly help our job in understanding and registering and indeed supervising these orders.
That's really helpful. And I might just bring you in here there, Judge O'Connor, in terms of somebody coming back looking for more. You seeing much of that? And again, I presume as you're getting better, not you, but as courts are getting better.
No, I include myself. Yeah, I think we are getting better in it, you know. There was some obvious mistakes that were being made at the beginning. But I'm hoping, I think, going forward that we did a reasonable job, I think, on doing the draft orders and the type of wording that should be used for various. We didn't cover everything, but but I think the message is getting out there.
Yeah. Thank you very much. And Anya, the points we'd say which Susie is making in terms of the other kinds of arrangements, how are things going?
There's been some there's been a slower burn there because they're new. Going to court and getting an order is somewhat familiar because we've had wardship for generations. So it has taken people longer to run with decision-making assistance agreements and co-decision-making agreements, but that is improving. We're seeing more of it. Again, we're trying to ensure people's proper understanding of what those are for. It's still not where you go first. As Susie has said, you don't need to be assessing capacity or thinking about the formal supports. That's not your starting point. Starting point is always to support people as far as possible in their own decision-making short of these supports. So I hope that through our work to promote understanding of the Act, though that there is an increasing resort to these arrangements, but only as they're needed. We find ourselves constantly saying to all sorts of people, the fact that this new grid of supports exists doesn't mean that you have to slot people into it when they might be fine as they are.
That's really helpful, and Sean always says a million webinars that the Act has tools that you don't have to.
Precision tools.
Precision tools. Thank you. And even better layering up of that. Sean, from a point of view of, we'd say you as a clinician, are you within the HSE? What kind of steps can be taken to give effect, I suppose, to that vision, which is that we recognise that these are tools rather than that they have to be used in all instances?
As you know, Mary, we've had a great take-up, really, from the hospitals of the various webinars trying to explain exactly how you use them. We still have other things to do. I was struck by the person not being in court themselves. Increasingly, we have been able to do this virtually. I think we're going to see more and more of people going with the laptops and being able to let the person and their character and what they're like come through better by being able to beam them into the court if they can't physically be there. So we need to be more aware of the possibility of doing these things if they are appropriate in individual circumstances. The training is going to continue. We have more training, particularly for assessments related to co-decision making and indeed powers of attorney, as well as for decision-making representation orders. So very specific training will be out shortly. But again, it's not about assessing capacity, it's about supporting people. And I think Susie's quite right, the guiding principles are the absolute core. And in fairness, all of the webinars we've done around the country, that's been the single message we've been put across, that the heart of the Act is the guiding principles. The rest are extras we can use as appropriate. So we just try and keep the message clear and consistent.
Thanks very much, Sean. Bibiana, I'm going to continue that theme of, in a sense, practical things, you know. So moving forward, and again, to talk a little bit about moving forward, what kind of practical things can we do to achieve, well, two senses, both to achieve that recognition that this isn't a straight off to court solution, but then also to support people if they do have to go to court. So I suppose that idea of practical solutions.
Yes, I guess more awareness on the guiding principle, that's on HSE consent policy. I think that will be at the top. Then optimize and build the capacity to support people to make their own decision, and that may mean make sure that the information is explained clearly and to the terms that they could understand, check if the hearing aids are working, glasses are working, using assistive technology, use any other facilities or techniques that are demonstrated to work for the person in order to maximize their capacity at the time, and keep the voice of the person central to any intervention. And we would like maybe to get a chance to hear in some of the cases the outcome of the order, so that we could go back and follow up. The cases that we've been involved in, and more increasingly towards the second part of this period, they are not just there for us to provide a report and then we close the case. They become our clients. We do meet with them and as long as it takes. And we do follow up on advocacy issues that are identified, and some are not part of the decision-making representation order. So we do continue, and would like to continue even more so once the order is issued, to see if there's any issue that could arise. And in terms of awareness, we developed a video that's very good in terms of public awareness of the EDM and the decision support levels, and that's called Minding Your Marbles, and it's on our website. It could be checked.
Lovely. Thank you very much. Susie, again, coming back to this idea of practical things to actually deliver on people's rights. And I suppose we have a mostly HSE audience here, and we also have a judge. What would you sort of say to them, we'd say, as a disability rights advocate, in terms of practical things that they could be doing, or all of us, I suppose, could be doing, both within the court, but then also within the services?
I think demonstrating how somebody's being supported in decisions and what has been done before those other options are explored. I think that's important, and about resourcing all staff and recognising within disability services that there are lots of people actually doing this every day already, and celebrating and rewarding that fact, and also passing the message on to others, because I think people who are working in social care and in nursing homes, who know people really well already, are already enhancing and supporting people in their decision making and their right to be seen as a decision maker. And I mean, we're still being surrounded by all of this concepts of next of kin. Yeah. And I know we're spending lots of time telling people that it doesn't have the rights that everybody thought it did. That needs to still continue. And I think also for family members and others to realise that, yes, there may be times when they do need to support people in decision making, but those times are not automatic. And it's a challenge, but it is a communication challenge, both for the HSE and for the services it funds, and for society in general, to support the fact that people with disabilities who, NAS would generally work with, are decision makers and have the rights to have bank accounts and or to have all of those decisions if they are able to, and be supported to develop their capacity on that. I'd also say it's really important in terms of the legal resources and other resources that who are working in these matters are aware of the role of advocacy and understand that. And NAS would be happy to continue to work, and we are working with lots of other partners to communicate what advocacy is, and that it is about standing alongside people, you know, and in front of them sometimes to defend them from others, and behind them to push people forward mainly, you know, to be heard. And I would echo what Bibiana says about having referrals and inquiries in early, so that people have the time before it ever gets near court to, you know, work with people on their will and preference, and to support them in communication with the legal representatives as well, and to ensure, and it is our role in us to make sure that the advocates, and, you know, we have staff around the country, that we're resourcing them to understand the processes and develop their practice as well, but also to hopefully support other legal professionals, clinicians and others in understanding the role of independent advocacy, that we can work together to support everybody.
That's fantastic, thank you very much. So we've got about, what, 3 minutes? Yeah, which means we can throw it open to ask, no. Oh, we have 3 minutes and then we can throw it open. Oh, excellent. The communications went a bit haywire there. The hand signals went a little bit off, or at least my reading of the hand signals went a little bit off. Anya, in terms of, I'm going to go for a kind of a practical one with you finally to conclude. Or at least, do you end up getting asked questions about what, you know, do people contact you saying, well, what can we do to make a DMRO, or do those kinds of queries come to you, and how typically do you respond, or what typically does?
We get all sorts of queries. I think we've had 17,000 queries, often from family members from a whole variety of people since last April. So whilst we don't own the court process at all, and as I've said, aren't involved, we never see the paperwork, we're not aware of what transpires in court, we see the order at the end of it. Yes, we do. We have a function under the Act to promote awareness and confidence, to provide information and guidance, and that would include pointing people in the right direction of how to progress an application to court, if that's the position that they're in and if that's generally what's required. And the court service does have a dedicated page or several pages on their website about that, including flowcharts and the form and everything. We also do have our own resources. We have on our own website your guide to a decision-making representation order with chapters in it on who can apply, what it means, how to apply, what it means to be a DMR. There are explainer videos and other resources there, and of course we have a code of practice for DMRs as well.
Yeah. Thank you. That's very, very helpful. And again, very useful to be aware of all the resources that are there, because there is a wealth of resources out there, which I think sometimes people don't realise. And I suppose it's also worth remembering just how young this Act is in terms of it being in practice. We've come a very long way. Yes, we're not there yet, and yes, it's not perfect, and there's a lot can be done, but we have come, I mean, even you were saying yourself, Judge, in terms of your own practice, that you've sort of seen kind of great advances, in a sense, over the...
Oh yeah, I mean, I think a lot of people were skeptical at the beginning. There's a lot of nostalgia, which is understandable. Why are we getting rid of a very safe...
Suddenly wardship, or a certain cohort of people fell in love with wardship.
Yeah, a safe system or whatever. But, it's international best practice. And I think that is, we see the problems around the world. I mean, what's the point of having laws unless we're going to do international best practice? And when you depart from that, you see that problems right around the world. And this Act does comply with the United Nations Convention. It is very detailed. I know it's quite complex, but I think we're all trying to get there.
Which is a lovely way to end this part of the discussion and to throw open for questions. So if you wouldn't mind, when the floating mic comes to you, if you would identify yourself and your background. So for any of the panel, delighted to have a chance to open this up to you. So anybody want to ask the first question, which is always kind of a hard one? Fantastic. Thank you very much. And if you would identify yourself, thank you.
Firstly, thank you so much for the opportunity, and thank you for just the evening. My name is Roisin. I'm a hospital-based geriatrician, and I'm dealing with a lot of this now. And it's really interesting to see that 74% of your orders are for people who just want to access the nursing home loan. And I think there are a lot of people in hospital who transition from home into nursing home care, and appropriately so in a lot of cases. And I think my experience is that there are a lot of people out there who need the order, because it's my understanding that they cannot use the co-decision maker in order to access the loan. That is my experience. They may not have capacity, and people don't know or have access to their financial, I suppose, information. What is happening typically is that we will do our report, and a lot of families are then going to their own solicitors, and there's quite a delay in, I suppose, the reports being submitted. We are being told that there's an 8-week delay for maybe Sage Advocacy, so that there's a waiting list so that the people aren't getting access to the advocacy. And then by the time the actual order is submitted, and I think it gets to court, we're being asked for updated reports. While all of this is going on, I've been very reluctant to send people anywhere else outside of the hospital, because I've been afraid that they will not have access to appropriate kind of social worker, I suppose, information and kind of guidance. And I know that families are finding the process very traumatic, and often at great expense if they go through their own solicitors. So my question really there is, one, do you have any, I suppose, information or guidance as to the updated report once it has gone to court, and what information or supplementary information you might want? And two is, how do you see this evolving for people who want to access the loan, and where it's appropriate to do that? Thank you.
That's brilliant. Thank you very much, Roisin. I might go to Judge O'Connor first, but then I might also go to Sean, to get the two perspectives from the court perspective, and then maybe the geriatrician. So that issue of delays and updated reports.
Yeah, and thank you, Roisin. That's an issue that was identified pretty early on. I mean, the first thing I'm supposed to point out is that when I say 4% are people who want access to the nursing home support scheme, they may also want other orders. So it's in that. But you're right, the nursing home support scheme tends to be quite urgent, particularly when they've had the 10-week transitional care and they don't apply for it until quite late in the application, and we run into funding issues. The vast majority, nearly all of the Section 48 interim orders that I've made are to do with the nursing home support scheme, and the HSE have accepted that as an order. So if I do have a comprehensive capacity report from someone like yourself, and if I have, even if all the paperwork isn't done, if I don't have necessarily I may not have the advocate's report in, I will park most of the other issues. But the nursing home support scheme I'll prioritise, and I might give an interim order in relation to that for 3 months, and that is accepted by the HSE, provided we give them notice on the basis that if it's going to be, the interim order is being revoked, that they're put on notice for obvious reasons.
Fantastic, Judge. And actually, while I have you on the subject of delays, because obviously I suppose things are probably moving a little more, maybe arguably smoothly in Dublin than possibly in other parts of the country. That issue of delay.
Well, it is a big problem, and one of the problems is that, to be blunt about it, the legal profession were quite slow. There are some people who are quite specialised in this area, and they're very good. But you saw 40% are lay litigants, and sometimes it's a choice. But in a lot of cases, because they can't get either legal representation or it's far too expensive. From the relevant person's point of view, there's the Legal Aid Board there, and they do need to be a bit more proactive. I mean, I shouldn't have to be the one giving out all the brochures and advising on the day, but I am in practice. They need to really be proactive and encourage it rather than actually be reactive. In other words, sometimes there's a second visit because they have to go and make an appointment with the... in an ideal situation, when we had the insolvency problems 10 years ago or more, MABS set up an office in the forecourts, and that was a huge plus. And insolvency didn't become the major problem that we thought it would become. If the Legal Aid Board, it's only a suggestion, but if they had an office in the forecourts, that would make such a difference in regards to it. Yeah, some practitioners have just run away from this, and some practitioners are just charging too much. It's not. But having said that, with the lay people are not the worst to deal with by any means in this. They actually go with you, by and large.
Yeah, that's really really interesting and valuable, though, to recognise, I suppose, the fact that there is a need for the legal profession to step up here.
Yeah, I mean, it's a fact of life. I mean, you know, lay litigants get a hard time sometimes, but the vast majority of lay litigants are in court because they can't afford legal representation. But we do have legal aid for the relevant person, and that has to be used. Yeah.
Thank you. And if there's one message to take away from this evening, that might be the one.
Yeah.
Sean, I might turn to you for the, we'd say, hospital-facing side of Roisin's question.
Yeah, thanks,
please.
Roisin. And certainly there were problems at the beginning. We've worked through a lot of them. Co-decision makers can actually make the application for ancillary state support. That wasn't clear at the outset.
No, it wasn't,
now. The other one that's very important is that even the people lack capacity, they don't need a decision-making representative just to go through a nursing home in many cases. It's the loan is a very complex type of decision. It's a mortgage, and that does require it. In other circumstances, you shouldn't. Increasingly, we've been able to help with the paperwork, and it really was quite daunting, particularly for lay litigants at the beginning. But we do have support for them available. So with the delayed transfer of care group, particularly, we've been working through some of the granular problems arising in the ground. They certainly did at the beginning, but we're continuing to work through them just to try and make it as good as we can. And then, as Judge OConnor has said, it's very important that we get our ducks in a row, really, in terms of the reports being high quality and reflecting the will of the person, will and preference of the person, engaging people, as Bibiane and Susie have said, early, if we're going to involve advocates or others. So it's a matter of all working together to try and make it slicker in that regard. So I think things have improved. Thank you.
Can I just say on that, all of these cases get priority. Now, I do know it's different down the country, but in Dublin, every Friday. So if the paperwork is done, you get listed straight off.
Yeah, I think it's probably the practices do vary. I mean, I think there is a feeling that there is a level of variation in terms of some of our questions. I'm assuming Siobhan is holding that because you have a question.
I have a question.
Oh, yeah, sure.
I'm a consultant psychiatrist for older people, and I'm just really curious to know what is the experience of an older person or a person who goes down to the courts. Like, I'm just reflecting on what you've said about hearing the voice of that person, of the relevant person. And, you know, for us as clinicians, if we're explaining to someone that their voice is required or expected in the court, can we tell them what that experience is going to be like for them? Thank you.
Yeah, we try and make it as comfortable as possible. I mean, we have got our courts with video link now in Dublin, and they're prioritised for courts that are going to be using this. Obviously, it's great. A lot of people can't obviously come in person, but also a lot of the applicants are elderly themselves in relation to it. So it can be quite daunting. We deal with them individually. So when somebody comes in, I would say maybe 4 cases between 10 and 11, and they're dealt with individually. We try and make it as comfortable as possible. I wear a suit. I don't wear the outfit. I try and explain what's involved in relation to the act, and so far as a lawyer can do plain English, and I explain why we're here and what we're trying to do in regards to it. We'll try and make it as comfortable as possible for it. I found, and in relation to the actual relevant person themselves, those that have either come into court or have been online, not all of them, because some of them don't have capacity to deal with it, but certainly some of them have appreciated, and certainly have appreciated even if complex decisions are being made for them, that their will and preferences are at least acknowledged.
Thank you very much, Judge. Any other questions? Yes, thank you.
Hi, Patricia Hickey, General Solicitor, Wards of Court. I just want to clarify in relation to fair deal, and I don't mean to put the fear into you, but I have found in the past the fair deal application can be more complicated in that you can make your application for your DMR or you can have your co-decision. But actually the main problem is not the applications or the form, it's the actual procedures in the fair deal. So for example, you might be applying for your loan, but you can't always register your loan. And that's more the difficulty I had engaged with. I'd found, and Jim Finn here is with me, the increase in applications for wardship in the last few years was because of fair deal. So it could be a case where I was appointed as committee. I would take the form, I would take everything, but that wasn't the problem. We need to look at the nursing home support scheme. I had considered judicially reviewing it myself, but I don't have to anymore, which is great. But This is the bigger problem. So you bring somebody into wardship, or you bring somebody into the Circuit Court DMR, or you have a co-decision. They can't actually progress the fair deal form. So you've given 10 weeks transition funding. Somebody's gone out to a nursing home, especially in terms of private nursing homes. The debt is rising up. They want to discharge the person. They can't fund it anymore. But it could take 2 years to complete an application. So the biggest problem I had for everybody in the room is if you have a person with a life interest, it is ascertainable for fair deal. But how do you sell a life interest? Your range man's not going to purchase it from you. So there's bigger problems with the fair deal application form than the actual getting to the stage where you give somebody authority to sign it. And I think that needs to be made wider known. I think most people here with the HSE are aware of the problems. I have solicitors here that make applications to myself at times, and I could be a year with the debt rising. So I think it's a bigger global problem that maybe we need to be more vocal as a group. We've got the ADMC sorted now, so this is a bigger issue, I think, that the HSE and solicitors need to be more vocal about, if that's of any assistance.
Thank you. That's very, very helpful. Thank you very much. Yes, Jacqueline? Hi.
Sorry, can you? Sorry. My name's Renee Summers. I work in the National Rehab Hospital ADM office. So the profile of our patients is often younger. The majority of DMRs that we've been putting in are typically for people in their 20s, 30s, 40s with a brain injury. My question is two-pronged, if you don't mind. It's about the capacity assessment and what's going into the reports. So I suppose the nature of the work that's done in the NRH is that interdisciplinary teams are, as a function of their general practice, supporting decision-making of patients, often on the very decisions that make up the DMR application, usually around place of care, where they're going to live, and financial management. This is done from the beginning of their admission until they're discharged. What we're finding so far in terms of feedback from professionals across the hospital is, in order to sufficiently provide a quality report so that a circuit court judge can understand who is this person, how have they been maximized to understand these decisions, and also why do you feel that they don't have capacity on these decisions? There's a lot of time that's needed to do a defined functional capacity assessment. So even if that work has already been done informally across several months, teams are finding to do the defined, sit down with the patient. This is now a capacity assessment for the DMR. It's replacing clinical time that the patient would have had for their rehab. So the question is it okay for teams in this circumstance to base their capacity assessment report on that informal work they've been doing with the patient on those specific decisions? And also just that we've been getting some pushback from other circuit courts on these reports being signed by more than one professional. So an interdisciplinary approach really has to be taken for these patients. We just want to make sure that's okay.
Thank you very much. Georgia, turn to you, and maybe Sean, you might have a
Yeah,
couple
I was
of
going to say
thoughts
maybe
on
Sean might comment as well. Well, first of all, I think an interdisciplinary report would be very useful, so I would find that very helpful. I think in the end of the day, you have to tell it as is. One of the problems is that all of us can try and go into each other's areas, but it's up for the judge to make the decision in the end of the day. And you do have to give the input in regards to it. But you can only tell it as is. I do accept that it is quite time consuming, and we do take all of that into account. And I accept acquired brain injuries are in a different category, because quite often you might have somebody who has an acquired brain injury and they may recover, or they may recover to a certain extent, so they are quite complicated. We're very heavily dependent, though, on those reports to be informed about what's involved.
Thanks a million. And Sean?
Yeah, I'm familiar with the NRH reports and the depth and quality of them. There are about the one set of reports are people dealing with people in depth over a prolonged period. that I would have thought will be able to do this readily. And remember, if you know somebody over a period, you're not required to empty your mind of everything you know about them. Because if you're going to be using and weighing information, which is often the trickiest one of the four-stage test, the people use and weigh based on their own values and beliefs. And you're starting from an advantage in that you have an idea about their values and beliefs and how to communicate with them and with the skill of SLTs. So just really important that you're starting from a great place and that, of course, the report can occur over time. There's no rule saying it has to be done on that day. It's much better done if you know somebody over a period, in my view. It is important to say in the acquired brain injury that ADM is not a detention law. So it's not about people who don't want to go to the nursing home, and this is how we make them do it. There may be reports and there may be court applications, but it won't be under ADM and not the circuit court. But in terms of the quality of the reports you provide already, I think keep doing what you're doing. I do suspect in a lot of cases people love the comfort of the team decide it. Often it is necessary that one person takes a responsibility and says, I vouch for the accuracy, I'm the guarantor of this, rather than saying we all signed it, which can be unsatisfactory sometimes. Thank you.
Would that be something you'd share that?
Yeah, no, I would.
Yeah.
100% I agree with that, yeah.
Thank you very much.
And also of the quality of the reports. I mean, fantastic, yeah.
Fantastic. One more question? Yes, somebody here in the front? Oh, sorry. We might do two more questions. But we'll keep the answers relatively succinct.
I'll be very quick. Thank you very much. My name is Aileen, and I'm a member of the National Patient and Service User Forum. And I suppose the question that's coming up a lot is, where does this start and finish with enduring power of attorney? You know, many years ago on a personal basis, you know, I speak for my dad, who is 92 and has vascular dementia, and is now in a nursing home, and we've gone through these experiences. But we were advised by a geriatrician way back, oh, you won't need that enduring power of attorney, because once this act comes in, that's everything sorted. But now I am aware you absolutely, in my experience, do need that enduring power of attorney. So can we get some clarity on that, please? Thank you.
Super. It's a really helpful question. I don't know, Judge, will we go to you or Sean, or a bit of both?
Well, maybe both, and maybe only.
Yeah.
Might have something.
Yeah, well, sorry. Of course. Yeah, apologies. Yeah.
Well, I mean,
yeah, actually,
everyone really in a way, and
yeah.
because, I mean, yes, it's the least restrictive approach. It's done, it's pre.
Yeah.
Yeah, it was bad advice, unfortunately.
Yeah, we do need them. Yeah.
Yes, everyone should have an enduring power of attorney, and it shouldn't just be associated with latent life planning. It seems to me too often it's been associated with elderly people, or worse again, when capacity has become a live issue. People shouldn't be leaving it until that point. An enduring power of attorney is a really valuable tool for planning ahead to ensure that your authentic voice is heard. The DMR isn't that, it's somebody deciding for you, albeit with regard to your will and preferences and with regard to the other guiding principles under the Act. An enduring power of attorney previously made under the Powers of Attorney Act 1996, it's still a good document, you don't need to do anything with it. If you're making one post-April of last year, then you're making the new Form 1, which has some different characteristics, including ongoing supervision of the performance of the attorney, but there's everything to recommend having an enduring power of attorney.
Want to add anything?
Yeah, I just apologise on behalf of the geriatricians that you got a bum steer in this idea. But
I do think there was probably that there were some people in the world, possibly still are, who don't necessarily understand the Act.
The Act was complex and it's come out.
Yeah. But that's a crystal clear answer, isn't it?
I echo what Anya says, and think about what plans you need to make. In the same way that you make a will, you might consider enduring power of attorney, you may consider advanced healthcare directive, and then you've dealt with just about everything that may unfortunately happen to you. So we encourage advanced planning, and advanced planning means, again, you get to decide later who's deciding for you. It won't be a DMR panel, you'll have decided in advance for a financial decision.
Bibiana?
Just to say, Think Ahead is again another resource that could be used as done by the Irish Hospice Foundation. And in relation with the attorneys and enduring power of attorneys, what we find is it's important for the people to speak with their attorneys and let them know their wishes and their preferences, so that when the time comes that the decision will be made by the attorneys, that they are informed by what the person would have wanted. And also when the enduring power of attorney is registered, and if there are issues with the attorneys carrying through the will and preference of the person, that there is this possibility to flag this to the DSS at the moment and get that addressed.
Fantastic, thank you. And our very last question. Well, you've got two of them now. So.
Hi, how are you all? My name is Breda and I work in Limerick. I just wanted to double check. It's great to hear that Dún Laoghaire have all of their staff, or the prescribed classes able to do the functional capacity assessment. How do we make that happen around the rest of the country, or are you aware of what the hold-up is with other people being trained?
You're off the hook for this one, Judge.
I think
and I'm off the hook for this one. And Sean, we're going to put you on the hook, I think. Siobhan, in fact. In fact, and we might segue into Siobhan's final presentation for that. Thank you, Siobhan.
Mary and Breda, thank you for that question. So I'll just start by commenting on that. Well, I'll introduce myself, Siobhan Ivry, and I'm the National Clinical Director for Integrated Care. But as it happens, my clinical background is working with older people as well. With regard to the prescribed professionals, we're working on developing a training programme that it was within the scope of practice. So we're working on that. Quiva, myself, Jacqueline, and other colleagues are working on that training programme to develop that, and we can talk to you a bit more about that. Is that okay? Yeah, okay. So just a couple of comments, and I'm conscious that everybody in the room is probably very interested in this topic, and maybe that's why you're here. But it is terrific to have a room full at this hour of the evening on a Wednesday night. And what strikes me most about today, about ADMA, is what a learning experience it has been for all of us. And for someone like myself, and many of us old age psychiatrists, geriatricians in the room, we've been practicing will and preference for a very long time. And yet the Act has come and taken us by surprise, despite all the preparation. I don't think there's any single voice of wisdom here. This really is a collaboration. It's a collaboration between ourselves and the HSE, but also with the legal system, be that Justice O'Connor, the Circuit Court, the Office of the Ward of Court, Chief Solicitor's Office, everybody who's here today on the legal side, also Anya and her colleagues in DSS, supervised under the auspices, of course, of the Mental Health Commission. And the other key people who are involved in this are advocacy services and those people who are users by experience, who have been beautifully represented, I have to say, by Susie here this evening. You've spoken just so well and reminded us what all this is about. One of the things as well about the Act is that we've had a lot of unexpected elements to it. I think most of us who were preparing expected that this would actually be more focused on disability. Almost so much of this has been focused on older persons, actually, in the last year. And hopefully that will change. And I know, Judge O'Connor, you've referenced hoping to see an increase in the number of cases. And of course, with the demographic that we have, that will be the case. But to go back to what Susie has said, we need to bring this back to the first principles. This is the final step, not the first step. And that's very important that we bear that in mind. I also think that it is an iterative process to understand what a person's will and preference is over time. And again, Susie, you referenced that, but also Judge O'Connor, you referenced it too, that you need to know the relevant person. So while you may be independent, you can be the clinician who knows that person over time. And again, going back to what you've said, Breda, we do need to bring our health and social care professionals in here. Those are the stories that we rely on to make these determinations. I think you've challenged us already. How do we bring the relevant person's voice into the room? That takes a lot of thought, and I think it's been a good answer to understand what will happen to somebody when they go down to the court. So I just want to thank all of you who've come this evening. I want to thank Mary, who's done a wonderful job, as always, on chairing. Mary, I think, round of applause. And a big thanks to our speakers, to Judge O'Connor, to Anya, Sean, Bibiana. It's the first time I met Bibiana in person. We've been on committee together for well over a year. And to Susie. I think you've been wonderful, so thank you again. And then finally, just to acknowledge the enormous work that's being done by my colleagues, Quiva, Jacqueline, Maria, Shem, who've organised this evening. I cannot speak for how wonderful they are to work with. What a fantastic team they are. And my co-chair, Margaret Brennan. So thank you all. Thank you. I'm glad to say the demonstration is out over and Kildare Street is open. So have a lovely evening. Thanks a million.